in a joint trial, while in Festo Androa Asenua and another versus Uganda, the Supreme Court held that a confessional statement includes not only the admission of the offense, but also the admission is of the substantiality of all incriminating facts. That which constitutes the offense. Apart from A1 and A2, none of the accused person is complained of being tortured. As already noted, the question of torture was determined during the trial within a trial. Accordingly, the charge and caution both the one recorded in Uganda and translated in English, were admitted and contained sufficient evidence to implicate A1, A2, A3, A4, and A5 in the kidnap of Nagirinya and Yasiibibwa. A1 repudiated the confessional statement he made and denied participating in the commission of the alleged offenses. The law relating to retracted and repudiated the confession is that a trial court should accept any confession which has been retracted or repudiated, or both retracted and repudiated, with caution, and must, before founding a conviction on such a confession, be fully satisfied that in all the circumstances of the case, the confession is true. The same standard of proof is required in all cases, and usually a court will only act on the confession if corroborated in some material particular by independent evidence accepted by the court. The law and the court may act on a confession alone if it is fully satisfied after considering all the material points and surrounding circumstances that the confession cannot but be true. See the case of Tuamoi versus Uganda. The charge and caution statement of A1 and the video scene reconstruction of the accused persons, which was admitted and tendered as could only be made by persons who were active participants and eyewitnesses to much of what occurred on the night of the offenses were committed. They seem to be familiar with what had transpired. It is true that A1 and A2 gave strong evidence in which they repudiated the confession and the statements made during the scene reconstruction. However, a number of factors exist to discredit any claim that this repudiation in any way affected the facts and events of the scene reconstruction. The statements could only have been made by a person who had actively participated in the incidents that were referred to. On the events leading up to the events would reasonably denote some knowledge as could only have been informed by the accused person's participation in the alleged offenses journey under consideration. This too goes to underscore the authenticity of the said confession as it is consistent with other testimonies of other prosecution witnesses. That's PW 9, PW 21. These people are saying that they did not make a rosy. Okay, A1 is saying he did not make those confessions. But the confession is also saying the same things which other prosecution witnesses have said. They are consistent with them. The evidence of PW 9, evidence of PW 21, the evidence of A3, the evidence of 5, is all consistent with what this man is saying to have said. Is it by coincidence that he was saying the truth, which turned out to be wrong? I doubt that. The prosecution also relied on the evidence of PW 21, who had used evidence of cold data analysis, which established what transpired between the accused person is. It was established as follows: that the user of the phone number 07704159552 was Kasolo Koporiyam. That the NIN number which was used to register the SIM card in 0706991311 was used in phone IME number 35743510772484, recovered by Kasolo Koporiyam at the time of his arrest. Of course, that phone was not tendered as an exhibit. They claimed it was lost. But at least we know that it exists. The report also revealed 29th August 2019 at about 2:28:20 hours. The call data also indicates that phone number 07004159 used by Kasolo Koporiyam was in location captured by Airtel site mast named ATL Mbuya, located at Mbuya, which covers areas of Chinawata and Mbuya, when he received a call from phone number 075-833-216 used by Mpanga Sharif, who was at a location in Weyogerere. Mbuya and Weyogerere along the route the suspects used that night to go to Mukono, where the victims were allegedly murdered from, and their bodies dumped. With regard to A2 Lubega Junction, they know your customer details show that the telephone number 070088662014 was registered in the names of Emmanuel Mpia under NINI number CM8701310 TNHF, which was recovered from Lubega Johnson at the time of arrest. Call data shows that the user of that same number I've referred to above, 0788, was based in the areas of Natete, Busega, and the number was used in ITEL handset of SIM cards. Specifically, they were SIM card ports, one is 357, ending with 40. The second, while the other one, SIM port was ending with 50, 3750. And then Mr. Lubega also had another second telephone number, 0708373340, which line Lubega always used to communicate to a number 0700415952 used by Mr. Kasolo Koporiyam, C. Annexure D. After Lubega was arrested on the 8th of September 2019, he used the phone number 0708373340 to call Kasolo on phone number 0700991311 while leading police to arrest Kasolo Koporiyam at 23:08 hours. And the report also revealed that phone number 0788662014 was inserted in the same handset port number IME 357360101817340 on the 21st of August 2019 at 1:39:33 and was used in the same handset up to 30th August 2019 when it was removed and reinserted on 1st of September 2019, then later used until 9th of September 2019. Between the 30th August 2019 and 1st September 2019, the line of the deceased Chiayimbwa was inserted in the same handset in the port where the phone number 0788 662014 was. The call data record of that same number shows that it was in the same ITEL handset with the phone number of Chitaimbwa Ronald on the 31st August at the time money was withdrawn from it. Now, the thing is lengthy, but we have no choice. Do we have a choice? It is very lengthy, but it seems we have to continue. The phone number, that is 0700415945 used by Kasolo, was inserted in the same handset in the SIM port number in the SIM port number IMI number 357-360-1018-17360 on the 1st of September at 4:15 p.m. up to 1st September, while the line of Chitaimbwa was in the same handset, in the same as of the time of 4:40 p.m. 40 is the seconds. Suffice it to say, from the data analysis report admitted as Exhibit 42, it indicates that the SIM card history of Chitaimbwa's line, that is 0755848732, indicates that after the crime, his phone number was inserted in the phone handset number IME number 357-360-10-1817-340 on the 31st of August 2019 at 7:48:32 up to 1st September 2019 at 4:36, during which time money was withdrawn from that mobile phone. In respect of one Kalyango Nasif, know your customer particulars show that the number 0753650028 was registered in the names of Nasuna Robina under Nini number C F9209810-4MHAC, and was being used in the handset which was recovered from Kalyango Nasif. Data record show that the user of phone number, that number which was being used by Nasif, was based in areas of Natete, Busega, and Hadi. Voice communication is with Kasolo Koprinam on number 0700415952. Then with Katerega Sadat 0708 90112. Then Rubega Johnson 0733 073 078373340, and Impanga Sharif on 07. So that number of Lubega had contacts around in Atete with these people according to the call data records. From Panga Sharif, that is A5. He's your customer details show that the number ending with 26 was registered in the names of Panga Sharif under Nini number CM 9504 5103MQNA, and was being used in a phone handset which was being used by Panga Sharif. And he received, Panga Sharif also received the calls from Kasolo Koporian on the other number I referred to, 0700415952, who was at the areas of Sayani alongside Gaba Road. All these are details. Now on the 29th of August 2019, at 1:23:27 hours, telephone number 075 8111216, used by Impanga Sharif while in the areas of Weyagore, received a call from 0711415952, used by Kasolo Kopori Yam, whose call was captured by the mast named ATC Chiboba. Chiboba is a village in Impoma Parish, Nama Sub-County, in Mukono, along Kayunga Road. Well, if you want to know, that was during the night of the offense. Phone number 078-3216, used by Impanga Sharif, moved that very night from the areas of Weyogerere to areas of Lunguja, Kosovo, where he was at 3:36:04 hours, where he made another voice call. As for Katerega Sadat, obtained call data records of number 0708190112 was being used in a phone handset number 3537371044894110. It indicates that Kasolo uses the same handset, that is of Katerega Sadat, on the second day of July 2019, from 11:34 up to the 3rd of July 2019, up to 12:35. And on the night of the kidnap and the murder, the phone was in the areas of Natete and the Lunguja from the 28th of August at 20:30 hours up to 29th of August, up to 5:38 hours. PW 21 stated that he established that after the eventual murder of Nagirinya Maria Kitaimbwa Ronald, Katerega Sadat, and Kiseka Hassan Masada and Kariango Nasif received back their colleagues, that is Kasolo Koporiam, Lubega Jonison, and Senabulia Isaac, who had gone to Mukono to complete the mission, and they all shared the money which they had robbed from the deceased person. The conclusion is from the above evidence of PW 21 were that Lwaki Johnson, Mpanga Sharif, Kariama Nasif, and one Fred, and Katerega Sadat had voice communications with the Kasolo Corporeum on telephone number 0700415952 before, during, and after the crime. Secondly, that during the 5 hours between the 28th of August 2019 and 22 hours on 29th of August 2019 at Kasolo Corporeum moved from areas of Natete, Rubaga, to areas of Chiboba, in Mukono and Baga to Natete within the same time. And Mpanga Sharif moved from areas of Natete to areas of Weyogerere and Baga to Natete. And now, thirdly, that the phone number 0783733340 of Lwaki Johnson was in the same handset with Chitaimbwa's phone number, that is 0755848732, on the 31st of August 2019 at 18:25 hours, when money was withdrawn from it. The line used by Kasolo was also used in the same handset, while the line of Chitaimbwa was still in it. I am aware that the evidence of the call data tendered in by PW21 is purely of a circumstantial nature. Circumstantial evidence must be a combination of facts creating a network through which there is no escape for the accused, because the facts taken as a whole do not admit any inference but of guilt. Circumstantial evidence should not only be consistent with the guilt of the accused, but should not be consistent with his innocence. See, we've already sucker on evidence. The way to deal with the circumstantial evidence was stated in Itofa versus Ara, where it was stated as follows: circumstantial evidence must always be narrowly examined, if only because evidence of this kind may be fabricated to cast suspicion on another. It is also necessary, before drawing the inference of the accused's guilt from circumstantial evidence, to be sure that there was no other coexisting circumstances which would weaken or destroy the inference of guilt. A4, Chiseka Hassan opted to keep quiet. So I'm going to consider the circumstantial evidence in light of those provisions. Yes, the implication was stated in the case of James Swawo Vili and another versus Uganda. A4, are you there? What is his name? Hassan. He kept quiet. An omission or neglect to challenge the evidence in chief on a material essential point by cross-examination will lead to an inference that the evidence is accepted, subject to its being assailed by inherently incredible or is possibly untrue. Subject to its being assailed as inherently incredible or possibly untrue. Yeah, unless it is untrue, of course. If you don't challenge evidence, it will be taken. So still, the courts must first prove that the evidence, it is the evidence is true before it can be taken against you, even if you keep quiet. So it is a matter of evidence, not because you kept quiet. It can be said that although the accused has a right to silence in criminal proceedings, this silence is not absolute, as an adverse inference can be drawn when the accused fails to challenge the evidence of the prosecution in cross-examination. However, a conviction cannot be based on inference alone drawn from silence. There must be some other evidence, because inference is weak evidence and might be too easy to jump to wrong conclusions. This means that inference must be backed by other types of evidence if a person is to be convicted. Kalyango Nassif. This is an initial. Kalyango Nassif gave evidence to the effect that it was Chisaka Hassan, A4, who brought A1, A3, and PW9 to him on that night to carry them. There was also evidence from PW21 who stated that A1 mentioned A4 as a part of the people involved in the commission of the alleged offense. Now, those are the observations I've made about A4. Now, Lwaki Kasolo, Lwaki Hassan put up the defense of alibi. This was, however, only brought up at the time they were giving their evidence. The end of the prosecution witnesses cross-examined on the alleged defenses of alibi. Neither did they raise their defense in their police statements or even notify the magistrate at the stage of committal to the High Court. In the case of Festo and Roa, Sonua and another versus Uganda, where the Supreme Court held, it was held by the Supreme case, that if an accused does not bring forward the defense of alibi until a month afterwards, there is naturally a doubt as to whether he or she has not been preparing it in the interval. To raise the alibi at the earliest opportunity gives the prosecution an opportunity to inquire into the defense. Therefore, where an accused person fails to give the notice to the prosecution and the court of his intention to rely on the defense of alibi before the hearing of the case, or fails to furnish particulars of the defense of alibi to the prosecution before the close of the case for the prosecution, as it was in this case, the court has discretion to disregard or not to accord weight to that defense. In May, the prosecution adduced sufficient evidence. They are discrediting the defense of alibi raised by Mr. Kasolo Koporiam and Rebecca Johnson. The prosecution, through the evidence of PW9, PW1, PW9, A3, A5. Okay, they didn't bring it by themselves. The defense which brought the evidence of A5 and A3. But still, they used it as their defense as well. Square placed at the scene, placed those people. At the scene of crime. The prosecution also adduced evidence which directly negated their testimonies that they were in other places. For the offense, for the defense of alibi, you say you were not there. There was evidence brought by witnesses to bring them to the scene. But as if that wasn't enough, even where they claimed it to have been, prosecution adduced evidence to show that those people were not at those scenes where they claimed it to have been. With regard to Kalyango Nassif, that is A3, and Impanga A5, they admitted that on the night they carried A1, A2, and PW9 to the scene of crime where Nagirinya Maria and Kitayimbwa Ronald were kidnapped from. A5 admitted to having seen A1 in a vehicle which had stopped them. I admitted having carried A1, A2, and a PW9, while A3 also admitted to having carried A1 and A2. A5 also testified that he had received a phone call informing him to go to Namamve to go and pick A1, A2, and PW9. He confirmed that he rode to Weyogerere, which also corroborates the evidence of the prosecution that after the commission of the alleged offences, they met with Kasolo Koporiam, Lubega, Johnson, Kariango Nasif, early morning hours of 29th August 2019, and they shared the proceeds of crime after robbing the victims of their phones and money. I am unable to believe that Kariango Nasif and Impanga Sharif were merely transporting Kasolo Koporiam and Lubega Johnson and Isaac Senabria, and their motives were not known to them. Why then would they communicate with strangers and meet up to share the proceeds with them, that is A1, A2, and PW9, if they were ordinary border men? The circumstantial evidence of the call data records so the circumstantial evidence of the call data records, their own admission, coupled with the evidence of PW9, points to a deliberate scheme orchestrated by them. I find that the evidence adduced by the prosecution witnesses, specifically PW9, and then the defense witnesses, that is A3 and A5, destroys the alibi of A1 and A2. The alibi set up by A1 and A2 is not true. It is a false alibi. That each of the accused persons, that is Koporiam, Kasolo, Lubega Johnson, Kariango Nasif, Kisaka Hassan, and Impanga Sharif, participated in the commission of the said offenses. Now, Section 20 of the Penal Code Act provides that when two or more persons form a common intention to prosecute an unlawful purpose in conjunction with one another, and in the prosecution of that purpose, an offense is committed of such a nature that its commission was a probable consequence of the prosecution of that purpose, each of them is deemed to have committed the offense. Common intention is the meeting of the mind of the accused persons, which is necessary to be present in joint charges. However, common intention may be inferred from the presence of the accused persons and the common intention may be inferred from the presence of the accused persons, their actions, and the omission of any of them to disassociate himself or herself from the assault or the act that they are guilty of. However, it should be noted that the mere presence of the accused person at the scene of crime is not final and conclusive proof of common intention. He must have participated in the activities of the other people. not just being there, even not being party to what was going on. In the case of Kasumba Kenneth and others versus Uganda, a specific unlawful purpose which led to the commission of the offense, if this can be shown, then the doctrine of common intention would apply, irrespective of whether the offense committed was the one who intended or not. The court also emphasized that it is now settled that an unlawful common intention does not imply a pre-arranged plan. You don't have to plan, but once you commit, you are part of those people, you will be taken to be part of them and you will be convicted accordingly. Amongst Mr. Kasolo Koproyam, Lwaki Johnson, Kalyango Nasif, Kiseka Hassan and Impanga Sharif, none of them dissociated themselves from the alleged offenses. None of them reported the incidents to police, but rather they all went into hiding until they were arrested. They were in direct communication at all times, as evidenced by the call data records, and even shared the proceeds from the crime. Mr. Kasolo, Lwaki Johnson, Kalyango Nasif, Kiseka Hassan, and Impanga are also culpable of all the offenses of kidnap, aggravated robbery, the offenses of aggravated kidnap, aggravated robbery, and murder, even if they may not all have been at all the scenes where all the offenses were committed. What is vital is that the acts of the accused persons were done in the pursuance of a criminal purpose held in common between them. I have also considered the conduct of the accused person after the commission of the offenses. PW8, that's Frank Nyakairo, described in great detail the chaotic atmosphere under which Ewan was arrested, that it involved fist fighting between Ewan and the security officers who arrested him, and that it was rough, and as a result, Ewan sustained the injuries which were captured in Exhibit P2. This information was supported by PW1, the investigating officer, who stated that the arrest of the accused person, number one, was chaotic. The culpability of the accused person is, as was decided in the case of R versus Tuvere. Also in the case of Uganda versus Sunday Herbert High Court criminal case number 6 of 2021, it was stated that the conduct of the accused can corroborate the complainant's testimony. For example, if the conduct of the accused indicates a sense of guilt on his part, such as escaping from arrest or running away, that can add strength to the prosecution case and point to his responsibility for the offense. I have noted the deliberate untruthfulness in the evidence of A1 and A2 when they denied knowing PW9, that accomplice witness. They denied also knowing A3 and A5, while A3 and A5 and the PW9 demonstrated to court through their evidence that they were together during that night. They just denied they didn't know them, yet the other fellows knew them and they said they were with them. A1 and A2 also lied when they claimed that they were tortured while in custody and that they were tortured by PW9, who was a police officer. They knew him before and he was an accomplice. They lied when they claimed not to have talked or coordinated with any of the accused persons on the phone, yet the call data records in the data analysis report tendered by PW1 indicated that they were in constant touch. There is sufficient evidence that A1 participated in the preparation, planning, and offenses committed by them. Lies are inconsistent with innocence. Proved lies can be used to corroborate prosecution evidence. See the case of Juma Ramadan versus the Republic. With regard to Katerega, Sadat, Katerega, where are you? A6, I find that there is no evidence to show that he participated in the events that led to the commission of the alleged offenses, except for his close association with the Kasolo Corporeum, that is A1. There was no sufficient evidence to show that he participated in planning execution of the alleged offenses. The call data records tendered by PW1 indicated that their communication with the Kasolo Corporeum was way before the offenses were committed. That was around the beginning of July. So could not have been involved. Neither was he identified by any of the witnesses as having participated in the commission of the said offenses. All the witnesses who were here never mentioned this man, other than PW8, who states that he was arrested as a result of human intelligence. The evidence of PW21 did not directly link him to the participation. Although he was mentioned by A1 in his charge and the caution statement, there was no other credible evidence linking him to the alleged offenses. There is a charge and a caution statement. Actually, we've not relied on that statement. We've relied on other evidence. It is just part of the evidence, but we've not relied on it. So just a mere mention of this man by A1 in the charge and the caution, still, there was no other evidence, so we found that he was not culpable. I find, therefore, that the prosecution proved beyond reasonable doubt that the Kasolo Corporeum, Lwaki John, Kalyang Nasif, Kiseka Hassan, and Impanga Sharif participated in the commission of the said offenses. There was sufficient evidence corroborating the evidence of PW9, who was an accomplice, and the evidence of A3 and A5, who were also the evidence of A3 and A5. So the evidence of PW9, A3 and A5 was of accomplices. So there was sufficient evidence to corroborate that circumstantial evidence. PW9 positively identified Kasolo, Lwaki, Kalyango, Mpanga, while A3 positively identified Kiseka Hassan as one of those border fellows who called the borders. There was also other circumstantial evidence of call data records, the communication matrix, scene reconstruction video, and the charge and caution statement of A1. All that was to corroborate the evidence of the circumstantial evidence of those witnesses. Accordingly, Kasolo Corporeum, Lwaki Johnson, Kalyango Nasif, Kiseka Hassan, Panga Sharif are hereby convicted of each of the offences that they were charged with. Katerega Sadat, the 6 is hereby acquitted of the said offence and should be set free, and is being held on other lawful grounds. I so find Mr. Kasolo Korea is there, A2 Lwaki Johnson is there, A3 Kalyango Nasif is there, A4 Siseka Hassan is there, A5 Mpanga Sharif is there. Were each charged and convicted on 2 counts of kidnap with intent to murder under section 245 3A 1A of the Penal Code Act, 2 counts of aggravated robbery under section 285 and 86 2 of the Penal Code Act, and 2 counts of murder under section 100 and 88 and 89 of the Penal Code Act. The offences were directly committed by A1 and A2, together with the one Isaac Senabulia, who pleaded guilty and was sentenced. The rest of the accused persons participated in the commission of the offences, but their culpability was below that of A1 and A2 and Isaac Senabulia. Well, A3, A4, and A5 only facilitated the commission of the alleged offences and later partook of the proceeds of the crimes. There is no clear reason or explanation why the accused person is committed the alleged offences, except for the motivation to get money. The murder of the victims was gruesome. It was terrible, and no amount of punishment would compensate the lives of the deceased persons. However, there is a need to punish such senseless crimes and deter others from committing similar offences. I noticed that A1 and A2 were not remorseful at all throughout the trial, and especially the conduct of A1, bordered on disruption of the proceedings. I hope you will learn still, shall give him the benefit of the doubt and be fair to him. There is a need for deterrence in order to discourage other offenders from committing similar offences against innocent victims with no provocation, as in this case. While reserving the capital sentence for A1, that is the capital punishment for A1 and A2, I find that there is a need for a severe sentence to save society from their dangerous dispositions. Accordingly, each of A1, that is Kasolo Kopriam, alias Arsenal, and A2, Lwaki Johnson, alias Eto, alias Manu, alias Rasta, is hereby sentenced to imprisonment for life on each count. The sentences shall run concurrently. Each of the accused persons, that is A1 and A2, shall serve imprisonment for the rest of their lives. That is the punishment. For A3, F1, and A5, each of them looked remorseful, and they are first offenders and were not actively involved in the committing of the alleged offences, that is of kidnap, aggravated robbery, and murder. I shall give them a chance to reform by being lenient to them. Accordingly, each of A3, Kalyango Nasif, A4, Kiseka Hassan, and A5, Panga Sharif, is sentenced to imprisonment for 30 years on each count. The sentences shall run concurrently, and the period each of them has served on remand shall be deducted from the sentence. I so order. If any of you is not satisfied with either the conviction and or sentence, you may appeal to the Court of Appeal within a period of 14 days from today.